Um, Welcome to Lower Makefield's June 6th zoning hearing board. We have 5 matters on our agenda tonight. We also have a new zoning hearing board member. Everybody, I'd like to introduce Masood Sial. He's sitting next to me. Welcome aboard, Masood. I also want to make note that we're hearing a continuance tonight that Masood did not participate in. So what I told Masood is, because we have 4 members tonight, 3 of us make a quorum. If after we relitigate the matter, if he doesn't feel that he comprehensively understands the matter, he can basically abstain for voting. It's going to be up to him. Although I feel like there's a good chance he probably will be able to understand the matter, but again, it's up to him. So if for some reason Masood abstains from voting, that would be the reason. Okay, so call to order. Our first appeal on the docket is Appeal 21-1906, deck, and they're requesting a 2-year extension of their building permits to commence at the end of the Commonwealth Court's appeal decision. So who do we have here representing the decks?
Evening. My name is Caroline Edwards. I'm actually the attorney for the Bowsingers, who are the legal owners of the property. The decks, who were the original applicants, were applicants under an agreement of sale. When the matter was appealed, they then terminated the agreement because they had a contingency in the agreement for zoning approval. So the Bowsingers are moving forward on behalf of the variances at this point. So if I could give you a little background, would that be helpful?
That would be perfect.
Great. So as I mentioned, in 2021, the Bowsingers, who own the properties that are the subject of the application, properties, it's 2 lots. One is more of a lane lot type lot, and one is a larger rectangular lot located off Woodland Drive in Lower Makefield Township. The Bowsingers had an agreement of sale for the property with the decks. The decks submitted application for variances to build a home on the property. The zoning hearing board granted the variances with conditions on February 1st, 2022. At the zoning hearing board hearings, the neighbors, Scott and Catherine McDonald, appeared as parties and participated in the hearings. And after the variances were granted, the McDonalds appealed that decision to the Court of Common Pleas of Bucks County on March 10th, 2022. The Bowsingers, under the municipality's planning code, had a right to intervene as the legal owners of the property, which they did within the time required. So they have been parties to the action until since very shortly after the appeal was filed, and they continue to be parties. The case proceeded through the Court of Common Pleas, and it's now before the Commonwealth Court of Pennsylvania, following an appeal by the McDonalds of a decision of the Bucks County Court in favor of the zoning hearing board.
So the Court of Common Pleas affirmed our decision?
Correct.
Okay.
The reason we're here tonight is that Lower Makefield Township has a provision in its zoning ordinance at section 200-105 that says that variances expire if an applicant fails to obtain a building permit within 2 years from the date of authorization. And the date of authorization would be the date of approval, which was February 1st, 2022. We're asking for an extension of that date from this board. The ordinance does say unless otherwise permitted by the zoning hearing board. So this board has the authority to extend that date. We're requesting an extension so that the deadline would be 2 years from the date that all appeals and all rights to appeal have expired. Until there's a final decision on the variances, on the appeal, the expenses of obtaining a building permit could be lost. Because if the appeal comes out against the Bowsingers, obviously the variances would not be valid and they couldn't proceed under the plans that they had prepared. In this particular case, the zoning hearing board imposed a number of conditions on the grant of the variances. And meeting those conditions will require the Bouncingers to incur significant costs. They include the preparation of revised plans showing changes to the wetland mitigation and plant density, which are required to be reviewed and approved by the township engineer and a landscape architect. They're also required to make other changes to show fencing and to show certain connection between roof gutters and downspouts. A conservation easement declaration of restrictions has to be prepared and finalized before a building permit will be issued. A floodplain survey has to be completed by a licensed surveyor, and plans showing the floodplain line must be prepared. And the stormwater management design must be reviewed and approved by the township engineer to show that it accounts for and handles the 100-year storm. So these are all significant expenses that require consultants, engineers, and attorneys to do work to get these done. We don't see that there's any benefit to be served by requiring the Bouncingers to incur these costs while the appeal is still pending. The Bouncingers haven't sat on their hands in this matter. They've been actively engaged in the appeal. They intervened immediately. When the record had not been sent to the Commonwealth Court, we filed the documentation to trigger the Court of Common Pleas to do that. And so we feel that we've done everything that we can to move the appeal forward. But obviously, the Bouncingers aren't the appellants. The McDonald's are the appellants. The deadline for obtaining the building permit currently is February 1st, 2024. And so we're already 2/3 of the way through that time period. This case isn't yet ready for decision by the Commonwealth Court. The McDonald's legal brief is due on July 12th, and the Bouncingers brief and that of the zoning hearing board will be due 30 days after the McDonald brief is submitted. After the briefs are filed with the Commonwealth Court typically will schedule oral argument. And after oral argument is held, they'll make a decision at some point, but there's no time requirement on the Commonwealth Court. I think it's unlikely that the Commonwealth Court would come to a decision before the deadline. But even if we say that maybe they will, the amount of work that the Bouncingers have to do to submit the building permit takes a lot of time, will take a lot of time. They have to make arrangements with the consultants to get the work done, get it submitted for the building permit, and actually allow time for the building permit to be issued. We're asking, though, that the Bouncingers not be required to incur those costs until the appeal has been decided, so that they know that they have rights in those variances. And just one last thing, what we're asking for, which is time to be tied to the end of the appeal period and expiration of any right of appeal, is consistent with how our legislature has handled protection from zoning changes for subdivision plans. So subdivision plans have 5 years of protection from the date of the preliminary plan approval. But the statute says that if an appeal is filed, then that time is extended for the duration of the appeal. So we're just asking for something consistent with that. And we think that that makes sense in this case particularly.
Okay, are you finished right now?
Yeah.
So I see Mr. Fenningham's online, but before we go to you, Mr. Fenningham, does anyone in the board have any questions? Matt, you okay?
I'm good.
So how did you arrive at 2 years as being the amount of time you would require post?
Because 2 years is what the ordinance provides. So it's 2 years from the date of approval.
I understand
in
that.
the ordinance. So we say we should have that. We shouldn't be penalized by the fact
I understand.
that the appeal's been filed.
Perfect. Thank you. And Mr. Fenningham, would you like to make your presentation?
Yes, thank you. Let me first thank Mr. Flager for inviting me to participate remotely, and also Caroline Edwards for not objecting to me doing so. And thank you for hearing me now. Let me just augment what Ms. Edwards said. in a couple of regards. The colloquy on December 21, 2021 by the zoning hearing board members at that time described the conditions as a requirement for the applicants to present additional evidence in support of the relief granted. It was clear that they were to do so as part of the ongoing land development process. I raised an objection saying that my clients would not be able to participate directly in that ongoing process. And so I asked for the right of my clients to participate in the post-hearing survey. That is the fifth condition of the December 21, 2021 transcript carried over into the decision of the zoning hearing board. Immediately after the December 21, 2021 final hearing before the board, I pursued Mr. Murphy, who represented the decks, in an effort to coordinate the immediate scheduling of the post-hearing survey to satisfy condition 5 of the board's decision. And I think it's important to just point out that I believe that fifth condition, though one of 5, that fifth condition is dispositive in that the issue that was raised and presented before the board by Mr. Giannotti, the expert for the decks, and by my client's expert, Vince Fioravanti, who is both a land surveyor and a civil engineer, presented the issue of whether the proposed residential structure's location was in or not in the floodplain. Mr. Fioravanti's exhibits and testimony was that it was clearly, the structure was clearly planned to be in the floodplain. And of course, Mr. Giannotti disputed that. The fifth condition was, I understood from the transcript, designed to address that very issue. I sought to pursue that because, as was described in the transcript of the December 21 hearing, if the structure is in the floodplain, then the decks, now the Bowsingers, cannot proceed because that area is protected under ordinance. In fact, the entire flag lot, which is where the structure will be proposed to be constructed, is 100% protected area. So I just want to say that as far as the Bowsingers timely, not delaying things, I pursued somebody to conduct the survey immediately. When the decks withdrew, and I was advised of that, and Miss Edwards entered her appearance, I immediately spoke with Caroline to again coordinate someone conducting the post-hearing survey for the reasons I mentioned. And I have been pursuing that ever since for 18 months. Let me just clarify what President Judge Finley actually ruled. He did deny the land use appeal by an order dated October 3, 2022. My clients then appealed to the Commonwealth Court. Under the procedures, we then filed with the trial court, Judge Finley, a document that's described as the matters complained of on appeal. As a result of Judge Finley reading that document and opposition to that, he entered what's referred to as a Rule 1925A order, memorandum opinion. Let me emphasize that memorandum opinion is not binding on the Commonwealth Court, it's advisory. However, what's important is that he stated expressly in his memorandum opinion that when he denied the McDonald's appeal, he assumed that the fifth condition post-hearing survey would be done, and I quote, in due time. When he read the matter of the errors, he then wrote a memorandum opinion dated December 18, 2022, in which he said and requested the Commonwealth Court to remand the appeal back to him so that he could take appropriate action in the context of the fifth condition, that is the post-hearing survey. And it's clear to me, and I believe to your solicitor, that Judge Finley would order the post-hearing survey to be done because of its dispositive nature in the context of the appeal. And he told the Commonwealth Court that if they remanded the case back to him, he would take appropriate action to resolve the appeal, possibly. Not, they didn't say he would resolve it, but it may be resolved. The zoning board decision did not state a deadline for this fifth condition to be fulfilled. For that reason, I don't think the zoning board has jurisdiction at this point in time, as the trial court does not have any more jurisdiction because of the appeal to the Commonwealth Court. I don't think the board respectfully can take action in regard to the conditions imposed back in 2022, the date that Caroline mentioned. I think the case has to stay as is, and the matter proceeds, which is the reason why I would still want to work with the Boussingers to coordinate the survey to be done as soon as possible. So I don't think a 2-year extension has any merit in regard to where the case is now. The concern is that my concern is that the Commonwealth Court may very well react to Judge Finley's memorandum opinion, and despite the briefs and the time and effort and expense to both parties, the Boussingers and my clients, the Commonwealth Court could very likely remand the case back to Judge Finley, which would, during that delay that Caroline mentioned, would only result in Judge Finley presumably ordering the fifth condition post-hearing survey to be conducted. So in my sense is, A, I don't think the board has jurisdiction to change its order, and changing the order is adding a deadline. Now saying, okay, you have 2 more years. I'll come back to the time period which I want to address. But I do think the board could simply take the request under advisement. I will say that Caroline and I are still working to try to find a way to resolve this appeal, including the post-hearing survey as a practical matter. So I think granting a 2-year extension and just allowing the Commonwealth Court to run its course and then waiting for Judge Finley possibly to issue an order is just delaying this even further. My clients are the ones that want to have the post-hearing survey conducted. And so we have been consistent in that position. I won't take issue with the significant cost. I don't think we're asking for all of the conditions to be fulfilled. They aren't necessarily what's at issue. The issue is the fifth condition with regard to the licensed surveyor doing the grid work to confirm whether the structure is in the floodplain or not. I've argued to the courts, and I will just say for your benefit to digest, that because this condition is dispositive, because the condition, it requires a further presentation, and because Mr. Connor said that if the results of the survey uphold Mr. Fioravanti's testimony, he would reverse his vote and it would become a 3-2 vote to deny the variance relief. So that's in the record. That makes this case somewhat unique in the context of where are we? And I would say, in opposition to Caroline's mentioning of the rule, the 2-year rule, the language of unless the zoning board extends it, that's not in the context of a case on appeal. That's in a context typically of an applicant who, for whatever reason, hasn't advanced the ball, whether it's a 1-year or 2-year validity period, and comes in with good cause and explains, I need more time. In that context, the board has the ability to reconsider under the MPC and your zoning ordinance, but not, I argue, when there's a pending appeal. That decision of the board cannot be modified by the zoning hearing board. So I think the issue is really coming back to either denying this request or taking it under advisement And I assure you that Caroline and I are in the midst of trying to come to some way to advance the ball in regard to the survey. And I think I don't want to speak for Caroline, but I think and Adam as well, but I think we all agree that if the outcome of the survey is the structure is in the floodplain, then the Bassingers can't move forward with the relief granted under that circumstance. There would have to be a new application and a new plan and so forth. If the structure is not in the floodplain, according to this post-hearing survey, there are still issues within the context of the other conditions and the issues that my clients have raised on appeal with regard to the adequacy of the stormwater management controls, the rain garden and the piping, and the flow of the surface water from above the Bassingers flag lot downstream through the creek. So this case has somewhat significant factual background to suggest that this request should be denied. The matter should proceed to keep everybody's feet to the fire, or you should take it under advisement and we will move forward post haste. My clients will, and I believe Caroline's clients will, to see if we cannot come up with a practical way to resolve the survey and then the issues of the stormwater management controls. And I thank you for the opportunity.
If I might respond very briefly.
Absolutely.
We didn't come here tonight to relitigate the zoning hearing board hearing.
Correct.
Intentionally, I didn't bring up the substantive issues because that's really not relevant to you. You didn't hear the case, or you all weren't here to hear that case. We're here on a totally separate issue, which is the provision of the zoning ordinance that limits the amount of time that a variance remains valid and able to be used. The ordinance, I assume, was put in place to avoid people just getting a variance and then 10 years later coming back in when there's been changes in the ordinance and all that sort of thing. And that's not what we have here. We have a situation where the appeal is completely outside the control of the property owner, but they're being subjected to that. I take issue with what Mr. Fenningham said about that the sole issue is this survey. There are six different conditions, which I recited when I was talking, that have to be met. The survey is one of them, definitely, the floodplain survey, but there are also other plans that need to be changed, other evaluations that need to be submitted to the township engineer. And all of those things together are significant costs. I don't agree that this board doesn't have the authority to consider a request for an extension. Certainly you wouldn't have authority to, well, let me just say that there are times when boards do come in, when applicants do come in and request a change of conditions at a later date due to a change of circumstance. Even though the board has previously ruled on it, they have the authority to consider something like that. This is specifically something that this board has to consider, and in terms of there's no other board to go to request an extension. And I think that it has happened before. I know it's happened in other municipalities that I've done business before, where they have considered requests of this type. I'm just going to reiterate, we would like a decision as soon as we can, because if it's a denial, then we need to move forward right away to get these plans done. Holding this off just delays, our ability to make decisions. And I'm just going to say that I do believe that if we got to February 2nd and we didn't have an extension and we somehow weren't able to get a building permit, that the McDonald's would be saying that the case is now moot because the variances have expired. So we would like to avoid that situation.
Do any of our board members have questions or comment?
I don't have a crystal ball and I don't have a tea leaves that will tell me what the Commonwealth Court is going to decide. or when they are going to get, as I say, around to it. There are several conditions, not just the one. I am inclined that if the Commonwealth has a provision for extending, I'm concerned, why is our ordinance in opposition when that was my major question, maybe our legal. I mean, if.
You're talking about the.
The-
MPC
Right.
provision, relating to subdivision, so it's dealing with different boards.
It's dealing with different boards. I understand that, but a subdivision,
But the
yeah,
local ordinance, our local ordinance permits the board to grant
the extension. I
which,
thought it
again, We
did.
don't do a lot, but we have done.
Yeah, I mean, I remember doing a few extensions or hearing them years ago. That was just it's just when you're dealing with the court system, you don't know what the time schedule is, and you cannot read the minds of we don't even, what judge or which judge is going to make
Yeah.
that decision.
And to Caroline's point, the Bossinger's reply brief, as well as the zoning board's reply brief, would be due presumably sometime in August. Oral argument could be scheduled sometime in the fall, and then anyone's guess as to how many months later you
Right.
actually get a decision on that.
I know that they don't move at a rapid pace.
Matt, you have any comments or questions?
No, I'm good.
Mr.
I see no reason not to grant an extension. It's pretty straightforward to, allow them to have some time as they go through their appeal process.
Yeah, I feel the same way. And quite frankly, Mr. Fenningham, I don't think we have the jurisdiction to actually go against our own ordinance. Judge Finley could have ordered the survey be done and he didn't. So at this point, I tend to agree with both Judy and Matt. But we still have to hear from public. Is there anybody in the audience here for public comment? Is there anyone online for public comment?
There's no one online at this time.
Okay, then I'm going to ask for a motion for Appeal 21-1906.
I'll make a motion to grant an extension for 2 years for 21-1906.
I'll second.
I just want you to clarify on the record, are you doing 2 years as the request is 2 years from the expiration of all
Correct.
appeals and any time period to appeal?
Correct.
Okay.
Do you need do you need Matt to reword that, or is that good enough?
No,
for the
that's
record?
as long as it's clarified on the record.
Okay,
I'm fine.
perfect. Can I get all those in favor, say aye. Aye.
Aye.
All those opposed? Motion passes.
Thank you very much. Taking the time.
Thank you.
So for everybody online in our audience, so Barb's talking to our court reporter, Bill Campbell, and we're waiting for him to get online so he can swear our witnesses in.
Beautiful. You don't get to swear in witnesses tonight.
Matt, I almost got to swear people in.
Oh, that's always a fun experience. You get to muddle the words about 5 or 6 times and then finally figure it out and it's time to go home.
Yeah. Hey, Bill, welcome.
Hey, sorry about that.
I've been there, so. Okay,
I'm ready.
let's move on. Next on the agenda is Appeal Z-23-2006, Sherry Nunez. And our court reporter, Bill, will swear you guys in. So turn your microphones on and talk into them, please.
Hello.
Have at it, Bill.
Hello?
Okay, do you guys solemnly swear the testimony about to give will be the truth, so help you God?
Yes, sir.
Yes.
Thank you.
Okay, so last time we left it, you guys opted to go with a continuance
Sir.
and revisit what you had initially proposed. So would you please present what you now propose?
Yes, sir. First of all, thank you guys for having us here again tonight. And from the last meeting, the pergola that we wanted to install was a foot from our 2 feet from our property line. And I think we suggested something around 4 foot would be okay. That was the number. So we called the manufacturer of the pergola to come out and look at where we want the pergola to be set in. And we could get it to 4 feet from the property line, but that's the furthest away from the property line that we can get it at this moment.
Is that because of the steps condition?
Yes, sir. And there's also a door.
Side gate.
The side gate has a door, and if you move the pole any more further, it's gonna be in the middle of the door.
Okay, so what we're looking at, Dan, is that still showing 2 foot, or is that showing the new revised 4 foot?
Excuse me, yeah, this is the original plan for 2 feet.
So anybody online or in the audience and everybody on the board, that's the original, but picture that just additional 2 feet over from the property line. That's what our applicants are proposing. Does anybody have any questions? Or comment?
There's also the issue with the wire overhead. Is that okay?
There was a question on how far it was.
Yeah. Peter brought that up.
Do you remember that, Dan?
I wasn't at the last meeting. Unfortunately, I don't.
And was
I
it the
don't
last
remember.
meeting?
I apologize.
So, oh boy.
So there's, I actually brought it up. So you can't be within 10 feet of a 15 kVA line.
Yes. But we're-
And,
I'm sorry.
and it's basically running right down the property line between these two houses.
So is that vertical or horizontal? 15 feet?
Horizontal.
You said 10 or 15? You said 15. I think he said 10.
Sorry, 10 is what
Oh, 10 feet. So basically what you're saying is this would have to be 10 feet off the property line to conform with the wire easement?
well, it's a safety issue for any of those wires, but I'm still going to contend it's a 3/4 acre lot, and I don't understand why we have to have why we're looking at a variance for something that's bumping right up against the property line when there's a huge backyard. I don't see the hardship.
I just want to be clear. I'm sorry, I didn't hear. So does it have to be from the property? So the power line's up here. Okay,
Yep.
here's my property line and the power line, and then the pergola is here. And from the top of the roof of the pergola to the power line because it's a slightly diagonal, it's not under it, slightly diagonal is 11 feet.
Right.
That's 11 feet. So is that okay? Or I have to be here and I have to be 11 feet like this way? I'm not sure.
So I don't work for the power company, but every project I've ever been involved with, I'm a civil engineer by trade. We've had to maintain a 10-foot horizontal separation between that line and the building.
Basically the fall line, right, Matt? Is that what you're talking
Yep.
about?
Yeah.
So
So if you drop a hammer from the bottom of that line and measure over from where it lands 10 feet, that's as close as you can get to it.
Okay. Yeah, then that won't work.
So, yeah, and Mr. Nunez, I do remember conversation going back and forth, and I don't recollect that us saying that if you moved it to 4 feet, we would all get behind it. We remember talking about, hey, we needed Jim, our engineer, to investigate the wire easement issue. Matt investigated it, it sounds like, and we also were just looking for any alternatives. What was the most you could move it over? What would make the most sense? So if you feel misled, I apologize, but I definitely don't recollect any of us saying if you moved it 4 feet, we would.
It wasn't misled. I think it was just a number. So it was suggested. It wasn't like something that I felt was said written in stone kind of thing. It was just.
I understand.
Yeah, I didn't hold anybody's word to it, but if that is also true, well, not also true, but if that's true with the wires, so can I stand up and show you guys? something?
Absolutely. Will you please take a microphone with you?
I start karaoke and I apologize. So right here, we have a power line and then we have to be 10 feet from here.
Correct.
Okay, I have a big property. I do agree with that. But across here, there's another power line all the way across. If you drop that, then it's 10 feet. I can't put the pergola anywhere. And then and then there's one from the house that goes from here to here. If I drop that one, I can't put it anywhere either.
Well, I know you guys don't want to put it right behind the house, but I think you can put it right behind the house. It's going to impact your view.
On the other side?
No, but between the pool and the house.
Oh.
I mean, I'm aware that it's going to impact your view and enjoyment of watching people in the pool and all that, but I mean, that is a legitimate place. You could put that patio and pergola.
Yeah, it's not that it's gonna really mess the view up, is we have huge windows. So those poles are gonna be somewhere where the windows are. And aesthetically, that's not pleasing to anybody. It's not.
So you mean but the view of them isn't aesthetically pleasing.
The view of the posts in the window.
Yeah, like in
Yeah,
the
the
middle
view
of
of the post in the
yeah,
window.
across the back of my house, right here, there's a huge window from the steps to about here. Then I have my kitchen window, then my dining room window, and then my living room window. And they're all pretty big windows. They're probably like, they're not normal sized windows. They're probably like 4 feet by 6 feet. Pretty big windows.
Yeah, I remember you guys talking about them. They sound nice.
Yeah, it's beautiful. It's beautiful.
I had a question. Now, you're talking about the power lines and being 10 foot. Do you have the authority to approve a variance to be less than 10 feet? I don't know, because is that a PTO thing or?
That's
To,
not
to
us.
be honest, the power line is not the issue at the end of the day. You have 190 feet from the edge of your pool to the rear of your property, and you're trying to jam everything down the side setback. I don't see where the hardship is in this project.
Yeah, it's just where we have it right there. It's like an outdoor living space. So when, in the event that does rain or there's some kind of weather, that pergola has louvers that automatically close. And we want to put a television also on the side of the house where the pergola is, so we can watch television if we want outside. So if we set it so many feet away from the house, all the way in the back, which I understand where you're talking about, for entertainment purposes, if we're cooking, we have to bring the food all the way out there, which I understand we have to walk. No, he's talking about we have 190 feet of backyard. So we can put it anywhere in the backyard,
All the way behind.
all the way behind the house, yeah.
But
Like anywhere around here? Are you talking about anywhere around here?
You can put it behind the pool. You can put it, you don't need a variance. You have a 3/4 acre lot.
Well, then we have power lines that cut us in half and then we have to go behind the power.
And I also believe since it's technically an accessory structure per our ordinance, it would, if they're doing what Matt's proposing, it would need to be in the back quarter of the lot furthest removed from the abutting streets.
I'm sorry, can you repeat that?
So like if someone's putting in a shed or any accessory structure, the ordinance says it has to be placed in the back fourth of the lot furthest removed from the abutting streets. So just for reference.
But does that apply to, this is basically a patio with a pergola? I mean, it's an outdoor recreational amenity.
It's a covered patio. I don't think it would be considered a
Okay,
shed. Yeah.
okay. If it's,
Yeah.
yeah, okay.
Yeah.
Yeah.
Then disregard, yeah.
So
Okay.
Adam, can you answer Sherry's question though? I mean, do we have the jurisdiction to grant a variance inside the easement area?
Here's the thing, that we don't have jurisdiction to mess with that. I think the problem would be, even if you granted it, the township could still deny the permit because of the issue with the wire.
Understood.
So, you know, what we're here for, the zoning issues that you do have control over. And what they're here for is the setback from the property line.
Correct.
Those other issues I think are more, I would think would be more germane to actually getting a building permit so they could actually do it. And if they're not going to get it, then I don't know that the board is inclined to grant relief that can never be actualized.
So before I ask for public comment, does anyone else on the board have any questions or comments? All right. Is there anybody in the audience here? Is there anybody online?
There's nobody online.
All right. Additional chance for further discussion. Matt, I have to agree with you, and I'm disappointed to tell you this, Mr. and Mrs. Nunez, but I really don't think you have a legitimate hardship case here. I don't. I mean, what I would suggest to you is we can take a vote right now, or if you're willing to move this thing somewhere inside where you don't need a, well, actually, it doesn't matter.
It's either make a
It's a
motion
moot point at that point. You don't need a
Right,
variance, so.
or withdraw.
Yeah, we
and-
might
and
as
go
well-
without the permit.
We might as well just, can I have, does someone want to give me a motion for a vote?
I'll make a motion to deny 23-2006.
I'll second.
All those in favor of the no vote? Oh. Discussion?
Nope.
I'll have a vote. All those in favor of the denial vote, say aye.
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 We have none opposed. Thanks for coming in front of us. I know it didn't go your way.
So we know more information.
You guys, you really can, you comported yourselves great. Seriously, thank you.
Thank you, guys.
And
No more done. I'm just kidding. Thank you.
all right. Next on our agenda is Appeal Z 23-2007. That would be Nathan Simcox / Hydroscape. Hi. You're going to be sworn in by our court reporter, Bill. Pull the microphone close, please.
You solemnly swear the testimony about to give will be the truth, so help you God?
Yes,
Thanks. Give me your name, sir.
Floor is yours.
I mean, let me just,
Oh,
mark some exhibits quickly. We have the application as A1, the plans as A2, proof of publication B1, proof of posting B2, and B3, notice to the neighbors.
I didn't hear him. And,
Just identify your.
did you identify yourself?
I'm Nathan Simcox, owner of Hydroscape Pools.
Okay, thanks, Nathan.
No problem.
Floor is yours.
Yeah, it's 73 Glen Drive, looking to install a fiberglass pool decking, concrete around. The allowable there was 13% of impervious coverage. This plan showed when we did an as-built was 15.5%. We're looking to be at 18.8% and remediated with stormwater management.
What is your stormwater management remediation?
I believe it infiltration trench.
And did you check the numbers?
Yes, that's correct. Me and Jim measured the numbers, and they're mitigating it back to the existing 15.5% with a infiltration. That
Okay, board members, questions, comments?
Is the project only the pool and the surrounding deck?
Yeah, they have existing fence, so I don't think there's much added on to the project. It's just fiberglass pool decking,
Okay.
regrade, all the soil erosion control. I think that's pretty much the extent of this one.
All right. And is it a concrete decking around it?
Yeah, concrete surround, cantilever, monolithic pour.
Okay. All right. I don't have any questions.
Mr. Vice Chair, just so you know, the township is participating in this application.
I'm sorry, I didn't hear you. So, Ms. Kirk, I assume you have some questions?
I do.
Floor is yours.
So, Mr. Simcox, based on the plan, it appears that the existing driveway is 1,630 square feet.
It's like I turned my,
Nathan, would you like to borrow a set of plans?
yeah, that'd be okay, because I didn't want to have the ringer on with it possibly. Loud. Said driveway.
Yeah, in the box, it says impervious surface calculations.
Yes, the 1630.
That's the existing square footage for the driveway.
Yeah, all this was done by Kavanaugh's as built, so I didn't personally measure, but this should be correct calc.
Okay, I'm just verifying the driveway runs along the side property line to the house.
Yes, yes, it does look like from the street, the left side, from my recollection,
Okay.
being there.
Now, the pool deck is proposed to be at 800 square feet, correct?
Yes,
How many feet, or how wide will the decking be around the pool?
it'd be typically 4 foot is the typical surround. So yeah, this is going to represent 4 feet surround.
All right, so there have been other applications where a typical coping is 3 feet. Is that a
Okay.
possibility of?
Well, no,
reducing it?
no, I am doing 4 foot surround.
And there is apparently a walkway from the back of the house to the pool that's going to be connected to the deck. How large is that area?
It'll all be compensated to that relative 800 square feet. That pool will be 520 square foot around at 4 foot of surround of 40 square foot is a typical 520. So from that 800, that means the rest of that that rest of that area be relative to 280 square feet.
Okay, so the reason I'm asking is because typically speaking, a variance request is supposed to represent the minimal relief necessary.
Okay.
Is there any way to reduce the size of the deck coping to bring that impervious surface coverage down, since the property already exceeds what is otherwise allowed under the zoning regulations?
Well, I mean, you could do a 3 foot surround, but functionality for a pool and somebody's usage, is one thing. But I mean, the compensation of stormwater management with the infiltration trench negates those numbers and actually just creates a non-runoff effect of that new impervious space or that recalc.
But your infiltration is to go back to the 15.7% that already exists at the property.
Yeah,
correct?
we should,
My concern is
well,
that
we should go back to 13. Seeing that, I agree when that was being said, looking at this, the idea of this going back from 15.5, why should we be at the regular? And typically we are. I didn't see that. And let me, maximum allowable impervious 13 in our reduction, existing impervious 15.5. Proposed is that.
is up to 18.8%. That's a fairly large increase.
It's a 5%. I think that's pretty standard in a lot of the approvals. We went from a lot of approvals I have in the past with Hydroscape through this through Lower Makefield here have been 24% over 18 has been a standard approved number in Lower Makefield Township.
Well, I don't think you have the ability to say that, not knowing all of the zoning regulations and variances that.
I'm saying the ones that I have been approved for hydroscape pools.
So my question is, if the board were inclined to grant the request, can the infiltration pit be designed to bring it back to a 13%
Yes.
impervious surface?
Yes,
Would that be an agreeable condition?
sure. 100%. No problem. We can change the size of the trench and accommodate that. That makes sense, certainly in overall thought in general.
Thank you.
Yes. No problem.
Why they pay her the big bucks.
All right. All right.
I think that was a great suggestion, by the way.
Thank you.
Yeah, I did hear that when you said that we were at 15.5 and I thought, 13 makes sense, right?
And I spoke with Jim Majewski earlier, and he said, when the house was built, these lots were originally R2 and they didn't have impervious back then, just for additional context. So I think the house was built with the intention to be able to handle 18%. So.
And I guess the township's concern is over the course of time, with more and more construction within the township, you have greater stormwater runoff.
Absolutely, yeah.
To the extent that they can create a pit to handle the stormwater flow back to 13% would be more beneficial for the property.
I agree. That makes sense. I just wanted to provide that context for the board.
Great.
So is there anybody in the audience here for public comment? Do we have anyone online?
One person.
Okay, person online, please come online, and our court reporter, Bill, will ask you your name and address and swear you in.
Have your name, address, please.
Yes, hi, it's Carolyn Abramson, 701 River Road.
Carolyn, do you solemnly swear the testimony about to give will be the truth, so help you God?
Yes.
All right, thank you.
So I only had a specific question with regards to the redesign of the floodplain on our abutting properties. So our property lies between the river and 73 Glen Drive. And with the redoing of the floodplain, the back part of our property is in a floodplain, as is the property behind us. Our concern is, as our property is higher, we're not necessarily concerned with runoff that flows from our property off of, to the back of our property, but the concern is now with the impervious surface that it could potentially come back to our property. I know that there's conversation with regards to pulling it back to the 13% impervious as far as the maintenance of the storm infiltration bed. But that was, frankly, our concern specific to the percentages that are proposed.
Thank you. I do think if we're going to vote on, when we propose to vote on this as part of the motion, Carolyn, we're going to ask that it be remediated all the way back to the 13%. So you're actually going to be in a better position than you are now, because at present they have 15.5% impervious. So you'll be 2.5% better.
And for context, the home is not in the 100-year-old floodplain, and it's not in the regulated AE zone.
Any further discussion amongst the board? I'll ask for a motion.
I'll make a motion to approve Z-23-2007 subject, for a maximum impervious surface of 18.8%, remediated back to 13%, subject to the review and approval by the township engineer.
I'll second.
Discussion? All those in favor?
Aye.
Aye. Congratulations, it's passed.
Mr. Doherty, tonight was the only application I was participating in, so may I be excused?
No.
We like you.
If this was Catholic school, no.
Pick me, pick me.
Okay, moving on as we matriculate through. Next on our agenda is Appeal Z 23-2008. Mark Havers. Good evening. Hello.
My name is Lucas Kaniewski. This is my wife Irina. That's Christopher. And we are the residents at the 1155 Big.
Okay, our court reporter Bill was going to swear you in.
If you're both going to testify, solemnly swear the testimony about to give will be the truth, so help you God.
Yes.
And before we do that, Adam, do you want to identify the exhibits?
Yes, please. We'll have the application as A1, the plans as A2, impervious surface calculations as A3, B1, proof of publication, B2, proof of posting, and B3, notice the neighbors.
Okay, floor is yours.
Thank you. We're looking to get an application to get our backyard finished to make it safe for our children. We're located on Big Oak Road, as you know very well that it's a very busy road. We're looking to fence in the property and finish it off a little bit in the back with a patio, potentially a pool, some cabana sitting area, and also a shed for some gardening equipment. And primarily is just to make sure it's safe for our kids so they don't run out into the front where the road is always busy and dangerous.
So we have currently 4 kids living in the house. 3 of ours, and then we're sponsoring a family from Ukraine with her so mother and a child. And I'm pregnant with the 4th, so we're gonna have 5 soon. So it's a busy household, and we would love to have an area in the backyard where all the kids can be kind of
Locked in.
gathered and locked in, and I can watch them from the sitting area. So I think that's why we're here.
All right, but before I ask for any questions or comment, there it is. I wanted you to pull that up. Thanks, Dan. You're already one step ahead of me. All right, any comments or questions from the board?
So is the driveway included in this?
In the impervious calculations, was the driveway included?
I wouldn't know. You have to ask.
I mean,
It was, yes. That's 1,900 square feet.
Right, but is it, no, I understand that. It's, I see the line 1,900 square feet, but is it part of this project? Because it looks to be new. I mean, it looks to be proposed. It's highlighted. It's more highlighted than the proposed pool. So I'm just trying to understand what's going on.
No, I don't, we're not changing the existing driveway.
Okay, so the driveway is not part. The only thing that we're adding is the proposed pool in the background, the cabana
Backyard.
and the shed. Okay. And are you providing mitigation for this?
I'm sorry.
are you providing stormwater management mitigation?
Yes, we probably could have to talk to Mark Havers and how to incorporate. We do have a rain garden in front. It's my understanding was built to be larger than originally proposed. So if there's anything extra that needs to be done, then sure we could be put into the.
So I spoke with Mark Havers, who I'm assuming is your engineer earlier, and he said that one of the stormwater management techniques you could do would be a seepage pit, which essentially they just cut a hole in the ground put rocks in it. And
That's what we have in the front currently.
I think that's existing and that only currently mitigates the impervious you have, but you'll need
Looks
to
like
have
it's size for the house and the driveway.
you'll have to create another one with this 2,800 square feet of impervious that you're proposing.
So somewhere in the corner in the back.
Yeah, that would be fine. Just needs to be 10 feet off the property line.
Yeah, I mean, it appears like you have plenty of room, and this is standard operating procedure. Anytime new improvements are being added that increase impervious to put a seepage bed in or pit.
And dimension wise, it could be, so you need 472 cubic feet of required control volume and one that is 4x8 and 38 feet long would be able to account for that increase in impervious.
What was that, Dan? 4x8 by what?
4x8 by 38.
By
And what's
38.
that?
38.
Sorry,
It's 4 foot deep,
8 foot wide
38.
and 38 feet long.
Okay.
10 feet off the property line.
Yes, sir. And that's just
Enterprise.
it doesn't need to be specifically to that dimension. That's kind of just a place to start, and you just need to be above that.
Oh, yeah.
Yeah, and I can provide you a copy of this to you and your engineer as well.
Okay, so we fill in we get the volume, then we got it.
Dan, what does that get them back to the 20.9%?
The allowable is 21.
Right.
Allowable is 21.
Does that get them back to the 21?
I believe it would get them back to the 20.9 existing.
20.9? Okay, all right.
Any other comment? Is there anyone in the audience here? Hi, would you please come up, stand at the podium and give us your name, address, and Bill will swear you in. Just make sure the microphone's on, please.
Hello? Okay. Can you hear me? Can you hear me? Yes. Okay.
Yep.
My name is Sandra Gozakowski. My address is 1205 Big Oak Road.
Ma'am, can you spell your last name for me?
Oh, you can't figure it out? Guzikowski.
Thank you. Do you solemnly swear the testimony about to give will be the truth, so help you God?
Yes.
Thank you.
Okay. So could I ask where exactly this proposed drainage pit would feasibly be put here?
Well, so I want to be clear. When Dan said 4x8 by 38, he was talking about 4 foot deep and then say 8 foot wide by 38, but it doesn't have to be 8 foot wide by 38. You know, it could be 12 foot wide by same number that would add up to whatever 4 times 38. Where's your property? It's, I mean, our township engineer is going to work with Mr. Havers, the engineer for the applicants, to determine the best location, but it will be within code, i.e. no closer than 10 feet to a property line. To be clear, it's an underground seepage bed. And
But if it fails, who's responsible for it? The township for permitting it or thinking it's good enough?
The owners, what do you mean by fail? And the owner's responsible for the systems.
Okay. So here's where I have questions to ask. I was present when this lot, the house and the house next to it was one lot in about 2007, give or take a year. The owner of that property at the time, Prime Properties, came in to get a subdivision. So 2 houses could be built. At that time, there was an awareness that stormwater was going to be an issue there. They were very serious. So they said, we're going to give you the limit. You build houses of that size that you're proposing. We're going to be very strict with that limit. Nancy Frick at that time said, make sure that subsequent owners are aware of that limit So they don't come asking for things that are going to be difficult to provide for them for variances. So my question is, this is a substantial addition, more impervious surface. So what has changed in that time?
I can't answer that question. I don't know what that time is, and I don't know if anything's changed.
So I say some 2007, the township, Nancy Frick specifically asked that it be put into disclosure agreements that this is going to be built to that impervious surface limit. And that, asking for something more, you're probably not going to get it. And there's a reason why with the stormwater. So there's that aspect. So let me continue, unless you want to address this right now.
I mean, yeah, Adam, I don't think we have the ability to look at it unless there's a deed
Yeah,
available.
that's what I was just asking Dan, if there's a deed restriction, that would be one thing. If there's no deed restriction and it was kind of just said, hey, we don't want this, has no legal effect. If there's a deed restriction that they can't build on the property, that would be a different story. I'm not aware of any deed restriction though. And again, I don't know if the applicants are.
So then I have a question. I was, as this was being built, I was keeping an eye on things because they were clearly encountering more water than they expected. As soon as they dug that basement, they were pumping water out 7 days a week. I was taking notice because they were pumping it into my field. And I went into Jim a couple times about that. So they ran into more water than they anticipated, what they planned for. That rain garden out front, I recall that being built. The original build with that, whatever you thought that could handle, it didn't. Because when it rained for the first time, it filled up like a swimming pool and it stayed full. They had to come back and nearly double the size of it. So I have concerns that you go, oh, we'll just add a drainage pit. And then what? When that fails, like how much more room are you going to take up? Listen, it looks awesome. Your plan looks awesome. But if that stormwater problem comes back and it affects me or any other neighbor where the stormwater management just isn't sufficient, it's your responsibility to make sure this is done right.
So, right. I mean, I'm only speaking for myself. I hear what you're saying, right? You have concerns. You saw a rain garden fail. I mean, I think it's a positive that people stepped in and they remediated it and they doubled the size of it. So the engineering on this stormwater management seepage bed is based on very good science. Okay, so it shouldn't, in your words, fail. It should not fail. We don't have a crystal ball. What we do is we make decisions based on, is in our minds adequate remediation being made? I think your point is, how do we know if it's adequate remediation? And we just have to trust the science. I will tell you, since I've been on the board, and I think other people can talk about that too, I'm unaware of people coming back and saying, you guys messed up and my yard's flooded now. I think we've had an overall positive effect because we're mitigating stormwater management back further than where it starts, just like the last case we heard, where they're at a current 15.5 and we're mitigating it back to 13%. So I would say, as an overall, our decisions have had a positive effect on the stormwater management in this township. And our township solicitor, Barbara Kirk, who was just here, takes this very seriously, as she just participated in the last matter. So in terms of guarantees, there's no such thing. But
The property owner will be responsible if there's an impact on neighbors.
they always are.
If it
fails per code, property owner is responsible.
Makes sense.
The decision is the zoning board's. As it relates to the specifications of a seepage pit or any type of mitigation efforts, then it goes to the township, for the engineer or Jim's office and Dan to then approve it, make sure that the calculations are correct, right? So whatever is being proposed will comply with what conditions the board implements, but it's then on the township to make sure those specifications match what the board does and to make sure that it's constructed and implemented properly so that it actually does work. And what I will say from my experience with a lot of municipalities, there's a lot of things that were done 15, 20 years ago that wouldn't necessarily be done now. And I think as Jim stated, in our experience with the board and working with the township, they're pretty good about making sure these things are right because it doesn't just affect them and you, it affects the township as a whole.
Yes, I was a little concerned that when the discussion came up for how are you going to mitigate it, we just ran around with some calculations right now. That feels like very last minute.
Well, that's not what's going to be approved tonight. It's going to be contingent upon the township engineer working in conjunction with their engineer, coming up with an approved plan together. It's going to be collaborative.
Okay.
Yeah, Dan just gave us the raw numbers. What would the numbers be to offset the cubic volume? That's all he did. So we could take those numbers and play with them any way we want.
There's still an engineer who needs to put together a design, needs to put together plans, submit it to the town. The town's engineer then reviews it, make sure they're comfortable with it, might want additional information or test pits or whatever as it goes through, but that's outside of the zoning board's jurisdiction. But this is just the first step.
Meaning the zoning board approves it. Let's say they approve it back down to the 21%, then it's on the contractors and engineers for the applicant to work with the township engineers to come up with the specific plan, but that specific plan has to comply with the conditions of the zoning hearing board, which is always that you have to remediate and mitigate. But since there's a whole number of ways to do that and a whole number of different configurations for what those seepage pits can be, we don't tell them it has to be the 38 by 8 by 4. It can be anything that would
Do the job.
offset that same amount. They can
Right.
work with the township and their specific piece of property to figure out where it best goes, how to best implement it, and
Yep.
but that has to get approved. Yeah, sometimes they do too, if depending on the size of the property.
One additional question on the fence. What type of fence? And how close will it be to my existing fence?
Fence will be in the front,
Mhm.
blocking off Big Oak Road. And the fence will be to the neighbor.
You're not
To the
doing,
right,
you're not doing fence against.
I'll
my
be,
fence.
I'll be keeping your fence as my fence. All right,
Pretty well for you, doesn't it?
well,
No, I'm joking.
it's,
beautiful. Enjoy satisfied that you will address. that was-
if I could, I wouldn't even put a fence, but the Big Oak Road is the primary issue I have.
I was just wondering if you were putting a fence up against my fence.
No
so
fence.
the amount of vegetation that grows up between them, that's-
Only the poison ivy that's there.
Just for reference,
We're good. I'm done.
All right, thank you.
just for reference, you will need to put a fence around the pool that needs to enclose the pool. It needs to be at least 4 foot high, self-latching, closing doors, meet fence code.
That's understood.
Is there any additional public comment? Board, any further comment?
I just curiosity, you just moved into this house a couple of months ago, right?
It would be February last year.
February last year, okay. And did you have it custom built or did you buy it from the builder after it was built?
We are renting.
Wait a minute, so you're renting this house?
Yes,
Wait, you're renting it now presently?
let's say this, it's, my family has a building company, Marmar, that built this house, and I am
Okay.
renting it from them.
Okay, Adam, does that have any bearing on us being able to render a decision?
Well, no, the app, it's still, The applicant is still the owner, though, I thought.
Let me take a look.
The owner says more and more builders on the Bucks County BOA.
Got it. Yeah, I mean, there's a lot of times, I mean, we had Nate Simcox previously. He's not the owner at all. He's just the contractor, so.
I mean, in this case, the applicant's the engineer.
And the engineer couldn't make it today because his daughter's graduating.
Yeah, so again, that as long as obviously they're not doing anything without the owner's approval, it just gives the approval. But a lot of times you have someone, whether it's a contractor or applicant on on behalf of the owner.
And public comment, I saw you raise your hand, or did we just satisfy what you were going to? Okay, so any additional further comment or questions?
Question.
Pull that in closer.
Then this rain garden size 8 by 12 by 30, this is the minimum requirement? This is the minimum requirement to offset the,
Yes, I believe that's what was approved at the land development process in order for it to be approved.
so to take care of her concern, can this size be increased to begin with?
The rain garden?
Yeah,
Are we talking about the rain garden or the proposed seepage bed?
a rain garden.
In the front, I'm not sure. That would, I guess, be up to the homeowner or at permitting time, I guess.
Right now, there's a rain garden in front of the house, and we're discussing a proposed seepage bed. So I'm just trying to make sure we're on the same page, Masood.
The seepage bath is on the back, right?
Yeah, the seepage bed's on the back.
I'm talking about that one, that can.
Okay, perfect.
In size,
Um,
begin with, because they have a lot of room on the back,
can they? Yeah, they can. However,
calculations.
not that we have any hard rules, but I would say generally we're comfortable getting back to just full remediation. I mean, but yeah, they could do anything.
Okay, that's it.
Okay, I'll entertain a motion.
I move that we grant appeal Z 23-2008 as long as the remediation returns back to the, let's see, I can't remember.
21.
I think it's, what is
20.9.
21%?
From 29.6 to 20.9.
Yeah, thank you.
Pending approval of our township engineer.
Thank you. Pending approval of the township engineer.
Can I have a second? I'll second it. Do we have any, no votes? All right, all those in favor? Aye.
Aye.
All those opposed? Okay. And we have one member who abstained.
Who abstained?
Matt, I didn't hear you vote. Did I miss you voting?
Nah, it concerns me that it was just built and we're already doing variances on it. So I'm abstaining.
You're abstaining or voting no?
I'm not going to vote no. I'm abstaining.
Don't question me, Adam.
No, you just have to state the reason for an abstention on the record. That's
I'm concerned that it was built in February and we're already seeking variances for it. So it's concerning.
Okay.
So Appeal Z 23-2008 has been approved pending the conditions cited in the motion. It was approved, 3 approvals and 1 abstention. Thank you.
Thank you very much. Thank you.
All right, we're done for the night. No, I'm kidding. All right. Last on our agenda, appeal number Z 232009. Please come forward, give us your name and address, and you'll be sworn in.
Alan Depew, 114 Dolington Road in Yardley.
Alan, do you solemnly swear the testimony about to give will be the truth, so help you God?
I do.
And before any testimony, Adam, would you please read the exhibits into record?
It would be my pleasure. So we have the application as A1, the plans as A2, the impervious surface calculations and the stormwater management small project volume control is going to be collectively marked as A3, B1 proof of publication, B2 proof of posting, and B3 notice to the neighbors.
Thank you. All right, Alan, you have the floor.
Thank you. Just real briefly, like many of our fellow residents here, looking to build an outdoor space. We have an existing deck, looking to add the patio as a landing for when our fur babies decide they want to track in mud, they have some extra additional spot, as well as just to further enhance the aesthetics of the property. I know that in speaking with Dan previously that it was when I bought the property nearly 10 years ago, I guess 10 years ago. It may have been a non-conforming lot at that time. The calculation was, I think, 22.7. And I think this bumps it up 1.7%. So just coming before the board to seek a variance, open to types of mediation, if granted. Obviously, I would prefer trees. There's a neighboring fence behind me. If you've been along those roads, that you may have seen that, I'd like to block that fence perhaps, but I'm open to conversation.
Well, I'm going to let Miss Judy Reese talk to you about trees.
How did I know that was coming?
Judy, let's talk.
I like trees.
I do.
Everyone knows I do. But you're the property holder now. We can't be guaranteed that said tree will how long it will survive, or if someone who moves in after you decides they don't like trees.
Sure.
We don't, unfortunately, our code doesn't protect trees that are already there with new ownership of a home. So although I hope you put in the trees, and yes, it will mitigate, it takes a long time before the tree is big enough. So you really have to do other mitigation.
I thought you did great. Any additional comment or questions?
What kind of patio are you sticking in?
I believe I submitted for a concrete patio.
Okay. So basically just poured in place. Okay.
Correct.
All right. My thought is maybe you could do a pervious patio. We could have a loose slate block and put stone underneath it, and you wouldn't have to do a as big of a detention system.
Okay.
I mean, we're not trying to talk you in anything. That's your
It's
preference.
it's what you want to do. I was just thinking of trying to be creative and think of a different way for you.
I mean, I'm thinking from a cost standpoint, it actually, if he's doing concrete patio, just doing the seepage bed for this amount of impervious over it, it's probably going to be cheaper to do a seepage bed than do the impervious pavers. That's just what I'm thinking. Matt, what do you think?
Cost really doesn't play a part in the total discussion. Again, it was just a way to maybe get away from doing the seepage bed if that's what he wanted to do. I really don't have a problem with the project as long as we mitigate. And you know, it's a relatively nice little patio outside of the existing deck. So yeah.
Matt, if I'm understanding your earlier point, if we did a paver patio, would that reduce the mitigation?
It might. I mean, you have to talk to Dan about it and see what's going on, see how it is. But if I've done this in the past where we did block with like a 1-inch separation and put stone underneath it, that basically compensated for the runoff by just getting absorbed underneath that patio. And then it's very shallow system. It's only like, 12 to whatever inches deep. And that every time the rain hits it, it grabs it, pulls it into the voids in the rock, and then it will slowly dissipate back into the soil. You don't have to worry about groundwater typically because it's such a shallow system. I'm sure Dan could talk to you about it if you want, but some of the materials out there are pretty nice when you get into concrete block. They get some nice finishes to it.
Yeah, I
Not sure what
think,
you're looking for.
EP Henry has pervious pavers. So I think a lot of the newer subdivisions near off Adobe Road have used them. So they seem to be pretty popular in terms of permits recently. So
And we can word our motion where you don't have to make a decision tonight.
Yeah.
Makes sense.
Sure, absolutely.
Yeah.
But I'll still put it in a tree for Judy.
There you go. She'll be very happy.
You're a mensch, Alan. Any additional comment or questions? Do we have any public comment online?
No public comment online.
Further discussion? I'll entertain a motion.
I'm gonna let Matt do this one.
Okay, I'll make a motion to approve Z-23-2009 for added impervious service to 24.4%, mitigating back to the hang on to that thought, Dan. What's the impervious surface ratio in this zone? I don't have it on my
18.
18, subject to mitigating back to 18% with review and approval by the township engineer.
Is that 22.7?
Did I say
Matt, he's
something
at
wrong?
22.7. He's going to 24.4 where 18 is allowable.
Correct.
So we're mitigating it back to 18, not 22.7.
Oh, sorry, 22.7, correct. My bad.
Do you want to take another run at it?
I can take another run at it. So make a motion to approve Z-23-2009 for proposed impervious surface ratio of 24.4% with mitigation back to 22.7%, subject to review and approval by the township engineer.
Can I get a second?
I'll second.
All those in favor?
Aye.
Aye. Motion passes.
Thank you, folks. Dan,
Thank
should I just contact you at the office? Okay. Have a great evening, Owen.
Good luck. Thank you. Before I ask for a motion to adjourn, is there any future business we need to discuss?
Is there an update on the tower?
August 1st.
Yeah, I thought it was August 1st.
August 1st. Okay.
And we have an agenda for June 20th, Dan? Next meeting?
sorry, can you repeat that?
June 20th, we have a meeting?
Yes.
Okay, we have.
And then will you decide about the first one at the next one? July 4th or July 3rd? I forget what it is.
Yeah, it would be the 3rd.
But the 20th is scheduled, yes.
Okay. Yeah, so, and we have that cleared July 3rd?
Yes, I think that's if we need it. It's scheduled, but I'm not sure how you guys want to handle it.
I'll be down the shore.
What?
I'll be.
No,
down the
you
shore.
won't.
No,
The shore's not that far
I
away.
will not be here on the 20th.
If we don't have the agenda, if we don't have any agenda items, you could do it now, or you could just do it on the 20th. We usually do it the meeting before.
Yeah, why
Let's do it
don't
on
we
the
table
20th.
that to the 20th?
No, I will not be here.
Anything else? I'll entertain a motion to adjourn.
I move that we adjourn.
Second.
All those in favor?
Aye.
Aye.
Thank you, everyone.